Good morning, attorneys. This is the court reporter. I need to know the cases that are requesting takedown, please. Are there any cases?
Ms. Court Reporter, this is Attorney Hannah Liebman in the matter of Benenac Capital versus Roberts and Jada Roberts. We were going to need a court reporter, Your Honor, but one of the defendants has filed for bankruptcy, so we're going to
call may be monitored or recorded. If you are a judge or court official calling in to conduct a scheduled.
Okay, I'm sorry, I missed that.
This is Attorney Hal Liebman in the matter of Benenac Capital versus Annie B. Roberts and Jada Roberts. We were going to request a court reporter, but one of the defendants has filed for bankruptcy now, so we're going to be requesting a continuance.
Okay, thank you.
Thank you.
If there are any changes, let us know. Thank you.
You got it.
Good morning, everyone.
Morning, Your Honor.
This is our civil motions and non-jury trial calendar. I'm just going to go through in the order and in the order in which I have them noticed, and we'll resolve everything that we can resolve today. Let's start with position 1, Wells Fargo Bank versus Ray Vaughn Lucas.
Good morning, Your Honor. Maya Bryant here for the plaintiff, Wells Fargo.
Harold Johnson here for the defendant, Ray Vaughn Lucas.
All right. I think the status we have here, we had granted a default judgment, I think in error, that was vacated. Defendant filed an answer. I believe there is now a jury trial demand.
Your Honor, we were actually able to settle this matter. We just need the repayment documents returned so we can get them submitted to the court.
All right. So
The settlement offer was drafted, and we have not been able to get that returned from our client. So if we can get the continuance of 30 days to protect our client's interest and to get him to sign the settlement agreement.
all right, we'll give you 30 days and we'll look for a dismissal.
Great, thank you, Your Honor.
Thanks, Your Honor.
Thank you both.
May I be excused?
You may be excused.
May I be excused as well?
Yes, sir. You may be
Thank you.
excused.
Have a great day.
All right, position 2, Ruiz versus Rizzle.
Yes.
And who do we have and on behalf of whom?
I don't know if Tanya's on there, but it's Tanya Grizzle and Eun Jung Yu.
And who are you, ma'am?
I'm part of with Tanya Warlaw Grizzle.
All right, we have no answer from the attorneys. I'll come back to that one.
Okay.
Position 3, Midland Credit Management versus Jarvis Hayes.
Sharice Teddy for the plaintiff, Your Honor. The status is, it looks like we filed our motion for default judgment. All the docs that we have attached to that. I believe we did attach a proposed order, but if the court needs it, I have another order I can provide today via email.
All right, I had a little difficulty with the affidavit.
Okay.
The affidavit, it doesn't authenticate the billing records and it doesn't reference any amount owed by defendant. It just looks like a generic general affidavit. And it's interesting because in The very next case, position 4 involving Darren Michael. I do
Yes,
have a proper affidavit in that one.
Well, I wonder if it was just a mistake, Your Honor, if on the Jarvis Hayes matter, if we could continue that for 30 days to allow us the opportunity to file an amended motion for default, including the proper affidavit.
All right, well, we'll give you 30 days on number 3. Let's go to number 4, where I think we have the proper affidavit. Darren Michael.
Yeah, I'm here, Your Honor.
All right. So, Mr. Michael, there's been a motion for default judgment filed against you. There was a complaint filed and there was no answer on record.
Your Honor, that is incorrect. I was in your court recently, and the attorney that was representing the plaintiff at the time and I went into a separate room to discuss a settlement, and we were close to terms, and where it left off was he said he was going to take it to be approved and he was going to get back to me. I did not have his contact information, so I had no idea how to reach out to him. I tried calling the company itself, and they had no idea of the conversation that took place. So I've just kind of been in no man's land trying to figure out what to do here, trying to get this thing resolved. And honestly, I'm a little bit dismayed that they didn't even have the courtesy to reach out to me to continue those conversations and get this resolved.
Do you remember who the attorney was that you spoke to last time around?
You know what? Shame on me for not getting his name. It was a gentleman, but I really don't know. I cannot recall what his name was, but there should be record of he and I going into that separate room to have that conversation.
Dark hair, Mr. Green?
I don't know. I don't know. I really don't, Your Honor. I apologize.
Your Honor, that's probably who it was. I don't have a problem continuing this again for 30 days. And in the meantime, provide Mr. Michael with whatever he needs as far as contacting information for the attorney of record, which is Claiborne Adcock. I have a phone number that I can give him, and I'll also advise Mr. Green and see if we can fill in some blanks as far as the settlement.
That would be great. I would appreciate any information that you could provide me so that I could follow up with him.
Great. So the phone number that now Mr. Green doesn't work for Claiborne Adcock. And actually the attorney of record on that is Ashley Bowman.
Okay.
And the phone number for her is 866
Okay.
300
Okay.
7850.
Okay.
I also have an email,
Okay.
il_ga@mcmcg.com.
Okay. I contacted her once by email with no response, so I hope that things are a little differently. So she's the one to reach out to, not this Claiborne Adcock. And who's Mr. Green? I'm just curious.
Mr. Green would have been an appearance counselor similar to myself today. I mean, very likely. He does these type of matters. So that's probably who you spoke with, although I can't guarantee it, but that's probably who you spoke with before.
Okay. We don't have a contact number for him specifically?
No, but I can make sure that he gets all the information necessary to Ashley.
Okay. I would definitely appreciate that, and let him know that that I'm really not happy with me having to go through this again when I was more than willing to do a settlement before. And I wish that he would have contacted me. I find that to be very unprofessional on his part.
Okay, I'll let him know.
I appreciate that. Thank you so much.
All right, well,
Thank you.
we'll give you 30 days to work that out, and then we'll come back and if not, we'll try and get it resolved again.
Thank you, Your
Thank you,
Honor.
Your Honor. I appreciate it. Thank
All
you,
right.
Grace.
No problem.
Okay, position 5 is JP Morgan Chase versus Canada. I see.
Yes, Your Honor, I'm here.
All right. Do we have counsel here for plaintiff? Oh, that's Mr. Marshall. So we're holding for Mr. Marshall. All right, we'll have to come back to that one. Counsel is advised that he's maybe late joining the call, so we'll come back to you, Mr. Cantor.
Just letting you know, we have a left of finish.
All right, let's go to position 6, National Collegiate Student Loan versus Ross.
Good morning, Your Honor. Sharice Teddy for plaintiff. John Ross, we have a motion for default judgment pending on this, Your Honor. I believe would have all of exhibits and the affidavit as well. And it should have included a proposed order.
I do not have an affidavit on authenticating business records. I have a motion, but no affidavit.
Your Honor, I am looking at the affidavit here, but I do not see where it has been filed. Let me see what date it was signed. Looks like we just received the affidavit on April 7th. So we'll submit that to the court, Your Honor, and by the end of business today, so that you can have that to consider our motion for default.
All right, if the affidavit is in order and you have an order for me to sign, then we can sign it without further hearing.
Thank you, Your Honor. We'll get it e-filed by end of business.
All right, position 7, which was National Collegiate Student Loan Trust versus Williams. That was a dismissal.
Correct.
All right, position 8, National Collegiate Student Loan Trust versus Michael Rodriguez.
Your Honor, this one is also settled. We anticipate the dismissal being filed shortly. We've settled this one as well. 30 days for dismissal.
Yes, we'll look for the dismissal on that one.
Thank you.
All right, position 9, IH2 borrower LP versus Nicole Harris.
Good morning, Your Honor, and Joseph Farah on behalf of plaintiff 2015-1 IH borrower. I expect our side to last about 25 to 30 minutes. This is an appeal of a landlord-tenant matter.
We have Ms. Harris.
Good morning, Judge.
Good morning.
I'm here with Ms. Ruiz.
Good morning.
Morning. All right, let's come, if we're going to need 20 minutes, you think, let's come back to that one. And I'll be prepared to hear your proof. I think we've got some other ones that we can get out quick. So just sit tight. Come back and hear that one. Let's go to position 10. JH Portfolio Debt Equities versus Jervis Scott.
Liz Brown on behalf of plaintiff.
Okay, do we have Jervis Scott? All right, we do not. I believe on this one, we've got a motion for default. I see a proper affidavit in the record. Did you submit a proposed judgment on that one?
I think we did. I think we filed a proposed order on the 23rd.
All right. So I think that is in the record. You have to verify you. Mr. Towns is going to verify that we have the judgment. I know we have a proper affidavit. So hold tight while we do that. In the meantime, I'll go to position 11, Unique Entertainment versus IMF Entertainment.
Good morning, Your Honor. This is Kyle Witt on behalf of the plaintiff in that case.
All right.
Morning, Your Honor.
Morning. So I think when we left last time, we had continued it to have a bench trial. I think that's my recollection, but in the meantime, defendant has filed a jury trial demand.
That is correct, Your Honor.
Obviously, we don't have a jury available right now, so it's going to have to be reset to a jury trial calendar whenever we can have one. I would much prefer to be able to resolve this as a bench trial, but you're entitled to a jury trial, so that's where we're at.
Yeah, if I could say one thing about this, Your Honor, as plaintiff, we've been through extensive trial prep in this case already. This is now, as you've mentioned, the third time that this trial has been set. The first time my client had to travel by air all the way down from New York to attend. It got reset until February of this year. We were ready to go in February. The defendant filed discovery requests about a week or so before the trial. We answered the discovery the best that we could before the trial date. We were ready to go in February of this year. It was then moved again because I think it was going to take an hour or 2 hours. And now we're ready to go again. And it just seems a little bit odd that the jury demand is filed now on, it looks like April 18th of this month. So it's just a little odd that the defendant's not ready to go now, but we understand that the court would have no choice but to grant the jury demand in this case. My client and I would just like to let the court know about what seems to be a little bit some unfair practice on the part of the defendant.
Well, at the conclusion of this matter, there are steps that can be taken if you think and I'm not saying that it is the case or it isn't the case, but if you have a strong belief that a party is unreasonably delaying or multiplying the proceedings, there are avenues to proceed under that. We can evaluate that. We can evaluate that on the merits. But other than that, the defendant has a right to a jury trial, and you can file it up until the time of trial. So,
and we certainly understand that, Your Honor, and we appreciate you allowing us to air some grievances on that part. But we certainly understand the position the defendant has taken, and that they are entitled to that right.
All right. Thank you both. The parties may be excused.
All right. Thank you, Your Honor. You have a good day.
All right. Position. Were you able to on our position 10, Mr. Townsend? Were you able to? All right. Judgment is there. So on JH portfolio debt equities, I have what I need. So we'll go ahead and enter the order on that one. So y'all may be excused on that one.
Thank you.
All right. Position 12 is Beninat Capital versus Roberts.
Hal Liebman for the plaintiff, Your Honor. Your Honor, this morning we received notice that the defendant, Annie B. Roberts, has filed for Chapter 13 bankruptcy. And as a result, we're researching if that stays the case as to the co-defendant, Jada Roberts. My initial reaction is that it is. So if we could go ahead and have this case stayed or reset for 30 days, Your Honor. And at that point in time, if we determine that the case is stayed while Annie Roberts is in a bankruptcy, we would go ahead and file a plea of stay, Your Honor, to put the court notice. But we just got the notice this morning that they filed for bankruptcy, Your Honor, Miss Annie Roberts.
All right. We'll continue it. Getting things in just under the wire for today's hearing. This is not the first one.
No, not gonna be the last either.
Nope. All right, thank you, counsel. Y'all may be excused.
Thank you, Your Honor.
All right, position 13. Wright versus Serene Beauty Lounge.
Franklin Evans for the plaintiff, Your Honor.
And Bruce Hedrick for the defendant.
All right, so I see there's a motion to extend time to file defensive pleadings. So,
Yes, Your Honor, and plaintiffs have no objection to it.
all right, so I think the proposed order sets out May 5th or somewhere around that date to file.
It does, although we'll file that quicker than that.
There's an order there. We'll go ahead and sign the order.
Thank you so much, Your Honor.
Thank you, Your Honor.
All right, y'all may be excused.
Thank you.
All right. Position 14, Rebel Lender versus for Hassan.
Greg Michelle for the plaintiff, Your Honor. I'm appearing. I think you know, but if not, the defendant filed a plea of stay on April 9th and apparently has filed Chapter 7 bankruptcy. So as far as I know, and best I can tell, the case is stayed, but I didn't want to just not show up to make sure that you were informed.
So where's your opposing counsel?
I don't know, Your Honor.
All right. Seems like that was another one of those late ones. We got the plea. As I recall from was some at least claimed that a bankruptcy had been filed before, and y'all objected to that, saying no, that wasn't a proper bankruptcy as to this defendant. That you don't have the similar concerns on this one?
I don't, Your Honor. I've checked the docket, and he did in fact file individual bankruptcy. So I think it is an appropriate stay.
All right. So that will be stayed, and I'll look to you to advise us as to when we can, if and when we can go back forward.
Okay. Thank you, Your Honor.
All right. Thank you, Mr. Mitchell.
May I be excused?
You may be excused.
All right. Take care.
All right. Let's go back to position 2, Ruiz versus Grizzle. Do we have Mr. Brisedo?
Yes, sir.
All right. So I saw that there was a settlement agreement filed. We need a dismissal.
Yes, sir. And we will get that file to you today.
All right, very good. I'm glad y'all were able to get it resolved, and hopefully that's the last time either side will see a courtroom about this one.
Yeah.
That's the idea.
All right. Y'all may be excused.
All right.
Thank you, Judge.
Thank you.
Your Honor, I have an announcement if you're ready for position 5.
5, I am. Yes.
Very good. I believe the court was holding for my report, Your Honor, and to make matters worse, I don't know if I should admit this. I entered the Zoom ID number for tomorrow's hearing, and I was waiting, and I don't, and then I finally figured out what happened. Your Honor, this had been continued previously for defendant to review his financial situation. I don't know if the defendant's present. We filed a motion for summary judgment last week with an affidavit. I'm not. If the defendant's not present, though, then we would have an additional motion.
I think Mr. Canada is here.
Yes, sir, I'm present. Okay. In that case, Your Honor, I suppose I'd like to discuss with Mr. Canada, see if he's determined how he wants to go forward.
Mr. Canada, so where you at? Do you want to resolve this, or are we going to have to go through the motion?
No, I'd like to get it resolved, Your Honor. Right.
So has there already been an offer or discussion of terms between the two of you, or do y'all need to have that discussion now?
I think we would need to have it in order to just finalize any terms we might have discussed previously.
Right. All right, I'm going to put y'all in the waiting room. Not in the waiting room. I need to create a breakout room. Yeah, I didn't mean to invite everybody. All right. I didn't execute that very well, but I think the right people got there. So I think that leaves us with our position 9 IH2 borrower LP versus Nicole Harris. Do we have Ms. Harris? We do not. All right, so I'm ready to hear y'all's proof.
And just before we proceed, I just want to be clear that the calendar was sent to her email address that was, listed, and that she has responded to that email address. In this particular time, we didn't send her a separate copy of the calendar. So, but I had received correspondence from the email address where the notice was sent. So I'm just letting the clerk know that.
There was proper notice. I think Mr. Townsend got some email correspondence today from her, which was not particularly coherent.
Oh, good.
Something
I mean, it's
about
good in the sense.
documents that could load or couldn't load, and
Well, then it sounds like she received notice then. We're ready to proceed, Your Honor. Would you like me to go ahead and present the case? It won't take 25 to 30 minutes then, in that respect.
all right, go ahead.
Okay. Your Honor, again, this is an appeal from a landlord-tenant case from 2017. This is, I think, our third or fourth time on the calendar, and the reasons in each instance have been from Ms. Harris. Hasn't been from us, but we were certainly happy to accommodate what appeared to be good reasons that she provided for continuing the case. I'd like to swear in my witness, Mentor Rahimi. Mr. Rahimi, do you swear to tell the truth in the matter before the court? You're on mute right now, so you can unmute yourself. Great.
Can you all hear me? I do.
Yes.
Yes, great.
Okay.
So, Your Honor, in this case, we're seeking rent in the amount of $10,097.37, which is less than the amount of the actual judgment. And the reason why was because there was some security deposit that was applied to the judgment amount from the magistrate court case. If that makes sense. Your Honor, I don't know if you need or would like to see the ledger. Otherwise, I'm just going to do it based on the testimony of Mr. Rahimi.
I believe y'all have already filed those exhibits.
Yes, sir. We did.
So I have skimmed them over. So I think he can just testify as to their the final totals.
Sure. Mr. Rahimi, I've stated to the judge that Invitation Homes, which is another name for 2015-1 IH2 Borrow LP, is seeking rent in the amount of $10,097.37. Have you reviewed the ledger to verify whether that amount is correct?
Yes, I did.
And does that amount consist of rent between May and in May of 2017 and November of 2017?
That is correct.
And the monthly total amounts of the rent were $2,118?
That is correct.
And Ms. Harris had a written lease with your company, Invitation Homes, correct?
Yes, sir. That is correct.
And Ms. Harris resided at the property of 3155 Cannon Street. Is that correct?
Yes, sir. In Atlanta, Georgia. Yep.
Okay. And the amount also included late fees of $211.80.
Yes.
Okay, so, and there was between May and November, there was 1 month where credit was given because there were water issues, and Ms. Harris basically had vacated the property, and Invitation Homes allowed her to not have to pay rent for that month that she was not living in that property, correct?
That is correct, yes. We've applied several concessions, yes.
And then also Invitation Homes had also paid around $9,000 for her to stay at a hotel during that month as well.
Yes, shy over 9,000.
And Invitation Homes is applied a credit of $2,300. It represents a security deposit?
Yes, sir. That is correct.
And this is based on your review of the business records of Invitation Homes?
Yes, sir.
And these are records that are made in the regular course of business?
Yes, sir.
And these are it is a regular part of Invitation Homes business practice to make these records at the time they're created?
Yes, sir. That is correct.
And you've personally reviewed these records?
Yes, I did individually, yes.
And you verify their accuracy?
That is correct, yes, sir.
Okay, Your Honor, at this time, we would ask the court enter a judgment in the amount of $10,097.37.
I'm sorry, who is speaking?
Nicole Harris.
Oh, Ms. Harris.
Yeah, I've been here. Yeah, I've been here from the beginning. Ever since you told them 20 minutes, I've been here at the start of the hearing. It kept kicking me out. And then you went into a break room and you put me in the break room, I think, because it said I'm in a break room.
I did not see your number at the beginning of our hearing. I did just let you into the hearing. Your number did appear, and I did let you into the hearing about 5 minutes ago.
Right, because it kicked me out. You put me in a break room with the other case, and then I had to go out and come back in.
All right, so do you understand that plaintiffs are asking for a judgment against you in the amount of $10,000 and some change?
Right, and I heard him speaking. That is, as far as them paying my hotel fees, that is incorrect. I paid my own hotel fees, and I got receipts of that. where I paid it myself with my American Express card. And as well, we were continuing because you wanted proof that they told me to move, and I have the proof with the emails between my attorney and their attorney, where I was given 30 days to leave the property. In June, I wasn't supposed to be charged rent because I was still in the hotel in June.
All right, Ms. Harris, we've had this conversation before.
Right.
And I told you that that the parties needed to see and hear that evidence. So
right.
That we would be able to respond to it.
Right. I sent it in, I emailed it because I have issues trying to upload it on the Odyssey. So I sent it to Trinity to upload it for me.
I don't, whatever you forwarded is not in any format that we can review.
Because it's emails between, and they have the emails, they have copies of the email because the email was between Joseph and my previous attorney. And I have the receipts, but previously you stated that I couldn't use any of that information. But it's coming up here today in court as far as what was paid for hotel expenses. And I paid my own hotel expenses.
So all of this relates to the issues that you raised in your lawsuit in DeKalb, is that right?
That's correct.
All right.
Well,
so I've already ruled that none of that is admissible here. That lawsuit.
Okay, but he's bringing it up. He's bringing it up. That's why he just testified on some of that information.
All right. Do you have any evidence to dispute the amount that they say is owed?
Yes, and that's the email I sent to Trinity.
And that email is about what? What you paid for hotel?
That email states that, hold on, let me pull it up. That email that was on August, Akila, I will be in touch with you. This is from Josh Huckabee, I think that's his name, the attorney. It says, Akila, I will be in touch with you early next week, but just to confirm, regardless of whether or not we are able to come to an agreement that we was trying to settle it, of this matter, is it your client's intention to be out on August the 15th? And that's the reply back. My trying to reply back because this was when it had to do with the attorney speaking with one another. I couldn't talk to the other side. She said, yes, regardless, she will be out by April the 15th. August the 15th. And I sent a copy of these emails because in the previous case, you wanted evidence to show that they agreed to let me move. So how are you going to charge me for something when you agreed to let me move for months? And I couldn't, the city health department was called, and also the water company was called. That place was not livable. Even when they fixed the property in June, it was another leak and mold build up. My doctor even stated and sent the letter in stating that I could not live in that due to my health conditions and the health conditions that it had already caused my family.
Your Honor, I'm a little, I'm not sure how to proceed here. She's presenting evidence. We haven't. I didn't actually know that she was even present. So I would have presented my case differently. That's not to say that I can't go back and present the evidence, notwithstanding what Ms. Harris has said. But I guess I'm looking to the court for guidance on how we're going to proceed with this case, because right now this is not really a way that we would normally proceed.
No,
Basically, I just want to get it resolved. Basically, just so I can move and this can come off. We don't even have to do any money. Let's just get this eviction off me. That's all. That's all I want. Because Invitation Homes know everything really what they did to me. You know. If I was able to present that case, the judge would have heard everything. You know, everything was wrong. It was wrong, what they did to me. You have fixed the property and then expected me to go back in there and stay. And then you stating that you paid hotel fees when I have receipts here where this hotel took my money. If you paid for it, why did they take my money? Then that means I need to go after that hotel for taking my money because they took over $3,000 from me. And I have receipts to prove that. Let's just get it resolved because, or mediate on it because you guys know the truth. Let's be truthful and honest. You know I don't owe you any money. You know y'all gave me permission to leave. You know that property was not livable, and I had to call out the health department and the water company. And they told me it wasn't livable.
Ms. Harris?
Yes.
I think you told me last time that you had a recording.
That was with the vice president of the company. It's going out, CA, it's freezing again. I had to put you on the phone and go in both ways, so that way I won't get kicked out. I'll still be on it. But it's froze again on my computer and I'm on the phone.
All
so
right.
Can you still hear me?
No, don't do that. Don't do that right now. This is obviously not the way that we should have a final hearing in this case. I was under the impression that Ms. Harris did not appear and was not going to be appearing. She's clearly appeared. She's tried to send documents. I've gone and looked at the email which she sent to Mr. Townsend. There are documents attached to it. It sounds like it looks like you have probably seen, counsel, some of those documents, but not all of them. Frankly, I just don't see how I can finally resolve this without an in-person hearing. And have it stand up, because I think if I don't have an opportunity in person for her to play and present all her evidence in a way that you can also see everything and respond to it, I don't know that we've had a full and complete hearing for both sides. And I recognize that y'all have been here at least 3 times, probably 4, to try and get this resolved with Ms. Harris. And I think I understand how it's going to be resolved. But I think we've got to resolve it so that when it is final, it really is final. That we don't have to come back, have this sent down from the Court of Appeals and have to do this again. So,
Your Honor, I just want to make sure I understand. I understand the court has concerns. I mean, I'm not averse to basically starting over, but if the court has concerns about the evidence that Ms. Harris wants to present, that this is not the forum where she's able to present the evidence, I guess I'm not sure what evidence that she would present to the court that would have an impact on the court's decision. I guess if she were to proffer what she says that this evidence is going to state, then maybe the court can consider whether it would be something that would even be relevant to the court's decision.
well, the only thing that she has said to me that I think would be relevant would be this recording
From the
that
vice
she was
president.
supposedly told
Mhm.
to leave. And so if she's told to go and that everything is a walkaway, then that's something that I would legitimately consider. But, you know, obviously, y'all have to hear that, and there has to be some kind of authentication of that. And I'm not sure that trying to do this online is the most efficient way to do that.
Well, I understand, Your Honor. I guess if that's the court's position, which makes sense, we would obviously want to be able to review that tape beforehand and have the opportunity to object to it. Of course, the court is correct that there should be a proper foundation laid for it.
I think y'all need to hear it, and I think, you know, she can play it for you before the hearing starts, and or y'all can make arrangements before, you know, before the trial date for y'all to either get a copy of it or hear it so that you can adequately respond to it. But to me, that's the only piece of evidence that she has proffered that would lead me not to or reconsider granting judgment in your favor.
Well, Your Honor, I guess the only other, one question I would ask Ms. Harris would be that when was the tape made? Because I think Mr. Rahimi would testify, even though she claims that she was going to move out in August, she had a pod on the property that was still there until November. And regardless of whether anyone said to her to move out or not, if she's got her stuff still on the property, they can't rent it out to another tenant. And I think that's the main issue.
The pod was on the street.
On the street in front of the property?
Like really the neighbor, in between the neighbor and that property. It wasn't in nobody's way, because my next door neighbor, we became friends, so it didn't bother them. And this is what happened. I had to get a date because I was moving to California. They couldn't pick the pod up for a certain time due to backup. But the pod was not in no one's way of keeping them from getting the property. And no one was going to be able to move in the property anyway, because the property was condemned with mold. And I have a recording that while I was in the property, the reason what made me move was because of the director of maintenance said they weren't going to no longer fix anything else in the property. That's the reason why the agreement was for me to go ahead and move out.
Yeah, I think Ms. Harris needs to be under oath, and she needs to be cross-examined, and I think it needs to be in person. And I think we need to have it. I think we need to have it. And I think we need to have it on the record.
Thank you, Your Honor. Yes.
Understood, Your Honor.
All right, we're pretty close. Since we won't need a jury, we're pretty close now to having the ability to have a properly spaced hearing in person in the courthouse and be able to publicly stream it. So we will set a hearing in person, and we'll set it within the next 60 days.
Yes, sir.
Thank you, Your Honor.
Mr. Rahimi, I apologize. We're going to get this resolved one way or the other. Again, I just want to make sure for you and for Ms. Harris that when we get it done, it's final and everybody's had a chance to make whatever argument they want to make before I enter judgment in this case.
We completely understand. Thank you so much, Your Honor.
So, Ms. Harris, you'll get notice and you'll need to bring everything with you to the courthouse.
Yes, sir.
All right. Thank you both. Well, everybody. Thank both sides. Y'all are
Thank you.
excused.
Thank you.
All right. Mr. Marshall and Mr. Kanda, I appreciate y'all's patience. Have y'all been able to
Yes, Your
resolve this?
Yes, we've reached a verbal agreement, and I've got the information needed to have that sent to Mr. Canada as in the form of a written agreement so that he can sign and return, and then we could submit to the court.
All right. We'll give you 30 days to get all of that resolved. I'm glad y'all were able to work it out, and then I'll look for a dismissal.
Thank you, Your Honor.
All right. Thank you both. Y'all have a good day.
You too.
All right. We'll do it for today.